been discussed in the wake of your arrest of your holding of Judy Miller and other issues in this trial. If there had been a federal shield law, and there may be in the future, how would that have affected your work? Are you for or against a federal shield law protecting reporters' confidentiality of sources?
Okay, I see there's three questions. Am I for or against the shield law? And I don't think I should, in my capacity, opine for the Department of Justice on the shield law. I know Mr. Comey gave some written testimony recently about one proposed shield law. Mr. Rosenberg, the U.S. Attorney in Texas, gave written and oral testimony in the Department of Justice. I'm not schooled to tell you what the Department of Justice position is on a shield law. I will also tell you that there are many people, and a shield law can be a very generic description. Does it mean an absolute shield? Is it a qualified shield? What are the exceptions? And I've heard lots of people comment that many versions of the shield law would still have allowed us to subpoena the testimony we did in this case. And I can tell you that the D.C. Circuit Court of Appeals affirmed Judge Hogan, who said if there was any qualified privilege, whatever the hurdle was, no matter how high, it was exceeded in this case. And I think what people ought to understand, I understand why it is that newspapers want sources, and I read newspapers, and I'm glad you have sources. This is different. This was a situation where the conversation between the official and the reporter may have been a crime itself. It wasn't someone saying, hey, so-and-so is doing something really, really awful down the hall, but I may get fired if I tell you. If you're transmitting classified information, it's the crime itself. But also, the reporter is the eyewitness. And what I think people don't appreciate is we interviewed lots of people, very high officials, before we ever went to the reporters. And if, as a parent, the grand jury is investigating to find out whether Mr. Libby lied under oath about his conversations with reporters, how could you ever resolve it without talking to the reporter? You couldn't walk in and responsibly charge someone for lying about a conversation when there were only two witnesses to it and you talked to one. That'd be insane. On the other hand, if you walked away from it with a belief that that conversation may have been falsely described under oath, you're walking away from your responsibility. And that's why, when the subpoenas are challenged, we put forward what it is that we knew, and we let judges pass on it. So I think people shouldn't read this exceptional case as being something more than it's not. And I think there's a pendulum that shifts. I'm not recommending that reporters be subpoenaed to my colleagues. I don't, it's not, this is not, we have to maintain a balance, and I think what people ought to recognize is that this was a narrow grounds, that they were justified, that we followed the Attorney General guidelines, that the court found that we satisfied those guidelines, the court found that we met any bar, the D.C. Circuit Court of Appeals affirmed unanimously, the Supreme Court declined certiorari, and I think we're going to step back, take a deep breath, and appreciate what the facts were here that are not the ordinary case before we rush into debates about balancing two very important things, the First Amendment and national security, and I don't take either lightly. Yes, sir.
Fitzgerald, can you say, does your request to witnesses that they not discuss the case publicly continue beyond this point through the trial? If so, how long will it continue for? And is there a point at which that request conceivably could impede Mr. Libby's right to gather witnesses and facts in his own behalf?
And let me ask you, I'll be perfectly frank, I haven't even thought about that. It'll be a long day, and maybe I need to sleep on that.
Well, but are you continuing to request, what about the first half of that? You're not sure if you think witnesses should remain silent?
I probably need to take a step back and figure out what requests we're going to make or not. I don't want to wing it from here if I haven't thought it through. Yes, sir.
You use the phrase "not quite done." There will be lots of speculation on what you mean. Can you help us by being any more specific?
No, because
Days, weeks.
if I choose other words, you're reading tea leaves, and don't, because I don't draw a very good tea leaf. So, if you're not quite trying to figure out what's going on in the grand jury, sorry, but that's a good thing. We're not supposed to tell you what's going on in the grand jury. I'm trying to let the public know that we're trying to do our job responsibly. We're trying to do things as quickly as we can, that we want to get things wrapped up. I've got plenty of other cases. I got a full-time job. Jack has a full-time job in Philadelphia. My full-time job is in Chicago. Everyone working on this case has another full-time job. So we want to get this resolved, but I'm trying to give you just a brief readout on where we are without compromising anything on the grand jury. Yes, sir.
How confident are you that there will be a trial?
Okay, that's not for me to determine, and I'm not going to. That's not a conversation I have through a camera, and I don't think. And in all seriousness, if in any case when I've been asked about people charged with other crimes, when people talk about plea bargains, you have to say, look, we've brought a serious charge, the person's presumed innocent. I'm not going to have a conversation about a plea bargain that assumes the person's willing to admit their guilt when they haven't been proven guilty. So that's for Mr. Libby and his counsel to decide, and I'm not going to be presumptuous, and I'm not going to discuss anything like that on national television. Yes, sir.
Maybe we can hone this down just a little bit, but we know that there cannot be a conspiracy of one, and he has not been charged with conspiracy. Considering that with which he is charged at this point, do you believe that Mr. Libby acted alone?
I'm not going to comment beyond the indictment. Don't read anything into that, but the indictment sets forth a charge. We're not going to go there. I've been told two more.
Let's assume we're winding down, or I'm going to have to give him water and we'll take a break.
Okay. I hope we're winding down.
Yes, ma'am. You said you're eager to go back to Chicago. How long do you think the second phase, the trial phase, might last? Years to a year?
I thought I ducked that question several times, but if I didn't, I'm not going to put a time frame on it as quickly as we can.
And secondly, if you impanel a second grand jury, is it always 18 months or is it 12 months?
I don't know. They vary, and I'm not going to give you any time frame questions because I'll be as vague as I have been already and just waste time.
In the absence of an independent counsel statute, there's been no suggestion here of political interference, and the Attorney General and the previous Attorney General both recused themselves. But I'm wondering, after what you've been through, whether you think the special counsel rules under which you conducted this investigation gave you the absolute assurances that you needed throughout the whole process that there could not possibly be political interference for your team by this or any future Justice Department.
Let me put it even more starkly. There was no political interference whatsoever with my team or our work on this case. That's all I can vouch for. Yes, sir.
Did Harriet Meyer's withdrawal yesterday have anything to do with the timing of your indictments today?
Okay. No. You did confuse me. Thank you.
Does the agent have anything to say?